Hi guys, it's Marieta, founder of ImmigrationBiz, business immigration attorney. Thank you so much for tuning in. If you are new here, welcome. Make sure to subscribe. And let's get started in this video. I kind of want to talk about the Proclamation 114 and 152 because some of you guys keep asking this question and I'm seeing this question over and over. So I decided to address these questions that you guys have, especially when it comes to immigration ban, right? So this is the immigration ban. If you remember, it was issued last year in 2020, first in April 22nd, and then it was also extended. So initial proclamation was 114, and then it was also extended and adding on top of that additional visa categories, which is called 152. And this particular proclamation is actually suspending the entry of immigrants and non-immigrants presenting risk to the United States labor market, right? So I will give you the overview for those who are confused, right? And then I also want to talk about the exceptions because right now you cannot enter United States if you are in this proclamation in these categories, right? And that being said, if you remember, former President Trump actually issued the extension of this proclamation. This proclamation was to expire last year, end of December, as you can see here, December 31st, 2020. However, he did extend this proclamation till end of March 2021. So right now, this proclamation is still valid and is still on. And that being said, you cannot enter United States right now, even though we have a bunch of different executive orders issued from President Biden. You cannot still enter United States if you are within these categories. However, what I want to do in this video, I do want to give you the overview, very brief overview, who is actually impacted by this, if you are still confused. And then I'm going to talk about exemptions. Here you can see under this particular proclamation, because just because this proclamation is valid, maybe some of you can actually enter and you might not even know it, right? So I do want to focus on this topic today. And definitely stick around till the end because you're going to learn everything you need, especially when it comes to this proclamation. Now, when it comes to travel ban, if you remember correctly, the travel ban was actually rescinded by former President Trump. However, then President Biden issued a proclamation banning entry from certain European countries, especially in Schengen zone countries, as well as South Africa, Brazil, UK, Ireland, and I made a video, so if you need, definitely watch the video. I will link that video for you. So if you are again from those countries, and especially if you spend the last 14 days in those countries, you are not able to travel to the United States and enter, even though you have a negative COVID-19 test. So I hope that is clear now. Obviously, I totally understand your concerns, guys. It's my wish that both of these bans will be revoked soon. And let's get started and let's talk about these particular proclamations. Two proclamations, 114, 152, suspending the entry of immigrants and non-immigrants, presenting a risk to the United States labor market. Okay, guys, so let's talk about this. So as you know, right now, who is impacted? Well, let me give you the overview. H1B, H2B, L visas, J1 visas, also dependents, meaning H4, L2, J2 visas are impacted. Now, proclamation does not apply to applicants who were in the United States on the effective day of the proclamation, June 24th, who had valid visa, right? So you already know this. Like if you had a valid visa back then, you should be able to enter the United States. This is really concerning people who at that time were outside of the United States. They did not have a valid visa in their passport and therefore they needed to go to the US Embassy to obtain these visas. Now, it is also impacting certain immigrant categories. However, I don't see it here for some reason. For some reason, I don't see it here. What I'll do, I'm going to link a video for you guys where I did actually explain these two proclamations in a greater detail, so you guys can definitely check it out. But let's talk about the exceptions, right? Because you guys want to know if you are exempt, right? So, here we go. Exemptions under PP 152 for certain travel in the national interest by non-immigrants may include the following. So the rule is that you cannot enter. However, if you are under one of these exceptions, then you can and go and apply for your visa. Okay, but I highly recommend that you check your the US embassy in your country, and check the information regarding the visa that you want to apply, because usually every single embassy is actually stating all the details. If you go ahead and read all the information available at their website, you should be able to find everything you need. So let's talk about the exception. Exception number 1, H-1B applicants. Now, for travel as public health and healthcare professionals, researcher, okay, especially when it comes to pandemic issues, if you are conducting medical research, you should be able to apply for exception. In that case, you can go to the embassy, schedule an interview, apply for the exception. Now, travel supported by request of the U.S. government agency or entity to meet critical U.S. foreign objectives. I mean, this is obvious. You will get your exception. Travel by applicants seeking to resume ongoing employment in the United States in the same position with the same employer and visa classification. So this means that if you were if you were employed by your employer in US and you had your visa and for whatever reason it expired and it's ongoing employment, you can still go and apply for your visa and you can still travel. So this is something I already mentioned in one of my videos long time ago. So just to be clear, this is concerning people who are resuming ongoing employment, not starting brand new employment, okay? Travel by technician, specialists, senior level managers, and other workers whose travel is necessary to facilitate immediate and continued economic recovery of the United States. And here we go. Officers might determine that H-1B visa applicants fall into this category when at least 2 of the following 5 indicators are present. So let's talk about these indicators. The petitioning employer has continued need for the service or labor to be performed by H-1B non-immigrant. LCAs approved by Department of Labor during or after July 2020 are more likely to account for the effects of COVID-19 pandemic on the US labor market. Therefore, this indicator is only present for cases with LCA approved during or after July 2020. Okay, so this is kind of obvious. You need to present updated, recent LCA approval, right? The certification, because otherwise it would reflect the old numbers, old data. These data, they were actually pre-pandemic, would not qualify under this particular exemption. Number 2, the applicant's proposed job duties or position within the petitioning company indicate the individual will provide significant and unique contributions to the employer meeting a critical infrastructure need. So obviously you need to submit sufficient evidence to really support this claim. Now, number 3, the wage rate paid to the H-1B applicant meaningfully exceeds prevailing wage rate by at least 15%, right? Because if that's the case, you are really needed. Your prevailing wage is exceeding the average pay rate. The H-1B applicant's education, training, experience demonstrate unusual expertise in the specialty occupation in which the applicant will be employed. And lastly, denial of the visa pursuant to this proclamation will cause financial hardship to the U.S. employer, right? If your employer can establish that it will suffer financial hardship, in that case, your visa must be issued. Moving on, H-2B applicants. So this is one of the exceptions. Travel based on request of the U.S. government agency or entity to meet critical foreign policy objectives. That's right. Moving on, travel necessary to facilitate immediate and continued economic recovery, right? So if you are working in a particular sector that is so important for the recovery of the U.S. economy, there you have it. And as well, you need to establish at least 2 of the following. So number one, the applicant must previously be employed and trained by the petitioning U.S. employer. So if that's the case, you're good to go. But also you need to establish, additionally to that, the applicant is traveling based on temporary labor certification that reflects continued need for the worker. And it has to be issued during or after July 2020. Obviously recent. Or denial of visa pursuant to this particular proclamation will cause financial hardship to the U.S. employer. So if your employer is able to establish that, you're good to go, you can apply. Now, let's move on. J1 applicants. So here we go. If you're traveling to provide care for minor U.S. citizen, LPR, which is the permanent resident, or non-immigrant in lawful status by au pair processing special skills required for a child with particular needs, you're good to go. If you're traveling as an au pair that prevents U.S. citizen, lawful permanent resident, or other non-immigrant in lawful status from becoming public health charge, you're good to go. Child care services provided for a child whose parents are involved with the provision of medical care to individuals who have contracted COVID-19. You're good to go. Exchange program conducted pursuant to MOU, statement of intent, or other valid agreement or arrangement between foreign government and any federal, state, or local government entity in the United States that is designed to promote U.S. national interest, you're good to go. Interns and trainees on U.S. government agency-sponsored programs, you're good to go. Specialized teachers in accredited education institutions with program number beginning with G5 on your Form DS 2019, you're good to go. Critical foreign policy objectives, you're good to go. Now let's move on to L1 applicants. L1A applicants are typically managers, typically founders of companies, typically people who have businesses abroad and they extended and opened the affiliated office in the United States, and now they are traveling to US to manage this business. However, L1 visas are banned. If you are in one of these exceptions, you can apply for your L1A visa. So what are the exceptions? Travel as a public health or healthcare professional researcher to alleviate the effects of COVID-19 pandemic, you're good to go. Travel based on request of the U.S. government agency, you're good to go. Travel by applicants seeking to resume ongoing employment. So for example, same thing with H-1B visa. If this is ongoing employment, if this started before pandemic and you need to return back because your visa expired, then you can apply for this exemption. You can apply for a visa. Travel by senior level executive or manager filing a critical business need of an employer meeting critical infrastructure need. Critical infrastructure sectors include chemical, communications, dams, defense industrial base, emergency services, energy, financial services, food and agriculture, government facilities, healthcare and public health, IT, nuclear reactors, transportation, and water systems. L1A applicant falls into this category when at least two of the following three are met. So let's talk about it. You will be in a senior level executive position or manager, or if you are the owner, founder, you has spent multiple years within the company overseas, indicating substantial knowledge and expertise within the organization, and will feel a critical business need for company meeting a critical infrastructure need. So two of the three. So if you're meeting these first two, you're good to go. If you're meeting the second and the third, you're good to go. If you're meeting the first or third, you're good to go. You don't need to worry about all of three requirements. L1A applicants seeking to establish new office. There is the answer to you guys. If you are seeking to establish new office, likely will not fall into this category unless two of the three criteria are met, and the new office will employ direct or indirectly 5 or more US workers. Okay? Interesting, isn't it? Interesting. My opinion, it's it's really counterproductive, especially when it comes to enhancing US economy. Like, why would you ban people who want to expand their businesses, open up new office and bring more money and enhance economy? Like, why would you not see this as something within the national interest? Like, personally, don't understand this thinking. Really don't. Now, I'm not going to go over the L1B applicants. You guys can read this. These are dependents, okay? National interest exceptions are available for those who will accompany or follow to join a principal applicant. So if your spouse gets the exception, then you can also get your exception, right? Exceptions under PP 114 for certain travel in national interest by immigrants might include applicants who are subject to aging out of their current visa classification, expires or within 2 weeks thereafter. So if you have a child who is under 21 and this child is aging out and it's 2 weeks after the application, then your child can still go with you. Now, here you can see this statement. Travelers who believe their travel falls into one of these categories or is otherwise in national interest might request visa application appointment. Okay, so guys, if you believe that you still are in the national interest waiver, then you can request your appointment. Otherwise, all these visas are still banned. So you cannot travel. First of all, you cannot travel because you don't have a visa. And you cannot even apply for your visa because you will not have issued visa if you are within these categories. However, if you are one of the exceptions, you're good to go. Now, that being said, for example, E2 visa, these are not included in this ridiculous proclamation. So that being said, you can apply for E2 visa. Most of my clients are E2 investors. They can apply for E2 visa. And when you think about it, E2 visa and L visa, in a way, they're similar, because many of these business owners, they are actually extending businesses to US. They're opening up affiliated offices, right, in the United States. And so I just don't get it. Like, on one hand, how can you, like, yeah, you're going to get E2 visa, but if you're not from the treaty country, you cannot get E2 visa, then you can apply for L visa. And here that sentence, that ridiculous sentence is that L1 applicants who are seeking to establish new office in the United States likely do not fall into this category unless 2 of the 3 criteria are met. A new office will employ direct or indirectly 5 or more US workers. I mean, when you think about it, like, it doesn't make any sense. Like, on one hand, you allow people to get E2 visa and come to US. On the other hand, you are not allowing people who are not from treaty countries. I mean, it doesn't make any sense to me, honestly. Alright guys, so I hope this was helpful. Let me know what you guys think. If you guys need a book consultation with me, go ahead, link is below this video. And if you are an entrepreneur, business owner who is seeking to start business in the United States in 2021, there is going to be a link for you guys. One link is going to show you how you get your E2 visa, get started with your business, number 1. Number 2, there's going to be a link how you can upgrade from E2 to a green card. There's also a training that I created. It's actually the whole blueprint. How can entrepreneurs get their PR? How can they start it? How they can actually move to US SAP even during pandemic and live their American dream, truly live their American dream, because during these circumstances under pandemic is rather difficult. So I hope that's gonna help you, and other than that, stay tuned for my upcoming videos, and I'll talk to you soon. Bye bye.